Alrighty, this will be the People News. One more time at it. Educational purposes only, okay? It's for you to think outside the box. Is things really going on and are we really true? And how can you consider yourself a true freedom if there's a fine attached to jaywalking across the street and that they're not allowing you to govern yourself, that you're subjects? Okay? If they can go down just by ticketing you or throw you in jail for just walking across the street, how can you truly call yourself free? All right? Now, it's going to be a little strange because it's going to be sovereign thing. And this one right here is going to be talking about how the plea bargain works and all that kind of stuff. Young man is great. So it's going to be a two-part video, and we're going to dig a little deeper, right? And I can't pronounce his name, Mr. Pipsqueak. So check him out, okay? Seems to be really intelligent young man, and but you gotta really listen to him because he's fast speaking. I can't keep up with him. I had to watch it a couple of times to put two and two together. Some of you guys may have to do the same.
You're in court, but will you? It's ironic that most of the people in Georgia's jails are awaiting trial because most of them will never get one. It is a commonly accepted fact that over 90% of criminal cases in the United States end not in trials, but in plea bargains. And according to the National Association of Criminal Defense Lawyers, that number is as high as 97%. By that number, only 3% of arrests ever go before a jury.
Yeah, which means you actually convicted yourself. Sit and think about that. You convicted yourself.
Remember, the right to a jury trial is a right granted by the Sixth Amendment of the United States Constitution. Why are so many Americans willing to give up their right to a trial? The reason is that sentences for crimes are just too high to justify the risk. Last season, we saw how Elder Freeman is facing an effective life sentence, despite the fact that Deputy Nelson obviously lied and Freeman is clearly innocent. So here's how it works. Police and prosecutors stack so many charges on the accused that he faces a sentence no one could possibly find reasonable or acceptable. Then they leave them to sit in jail for as long as they possibly can, and then when they're ready, they make an offer. If you plead guilty, we'll give you a lighter sentence, like time served or probation. But if you demand
On the average basis, it's 2 years in Texas. Average. Okay? And then, people give up and plea out. Have heard up to 5 years, even.
your right to a trial, we'll tell the judge you have no remorse for your crimes and seek the highest sentence. This is what lawyers call the trial penalty, and it scares the overwhelming majority of defendants into giving up their rights and making a plea. According to the National Association of Criminal Defense Lawyers, this kind of coercive plea bargaining was deemed unconstitutional by the U.S. Supreme Court into the 1960s. But then, they suddenly changed their mind. In 1970, the court ruled in Brady v. the United States that a defendant who had pled guilty in order to avoid the possibility of the death penalty had done so voluntarily. This opened the floodgates to allow prosecutors to use heavy sentences as leverage to get guilty pleas. So what would you do? If you were accused of a crime you didn't commit, would you roll the dice, risking life in prison on a bet that the jury will get it right? Or would you falsely admit your guilt, take probation, and go home? Over 90% of people wouldn't take the gamble. And this helps explain...
Well, and sit and think about that, y'all. Why wouldn't they? Because juries don't even know their own basic rights. So how can you really trust any juries? And the prosecutor's allowed to lie to the grand jury, which the grand jury can indict a ham sandwich because the prosecutor lied so good about it. And guess what? There's no repercussion. Why? Because they have qualified immunity. This qualified immunity crap has got to go. literally. And that's the Fifth Circuit said that when they guys sued the prosecutor for lying to the grand jury when he got the paperwork and all that kind of stuff. I don't know how he did it here in Texas. And the Fifth Circuit says, well, he's got qualified immunity. So that right there by the Fifth Circuit saying the prosecutor can lie to the grand jury due to qualified immunity. Ain't that some crap, y'all?
And why so many Georgians are on probation. Turns out the overwhelming majority of people who are arrested and convicted never get their day in court. But this is a serious problem, because it means that we have no idea whether or not convicts are guilty. The evidence never sees the light of day, and the jury never looks at the case. So you've been told that you'll get your day in court. But will you? The statistics say you won't. Odds are good that if the blue lights come on, you'll be presumed guilty and be made to pay the penalty without ever receiving a trial. I'm Mr. Pipsqueak signing off, and remember, you should never talk to police without your parents and a lawyer present.
Hear, hear, young man. Hear, hear. I love the parent thing because I taught my grandbaby that. I don't answer questions without Papa. And he had to use it in school a couple of times. All right. So let's backtrack to here because this is going to be more of an interesting deal as well.
Big play.
To me,
Bigger flavor.
It is more interesting to me because I heard something last week. All right, about this thing. Okay, it wasn't on the documents, but attorney asked a man doing a plea bargain, by the way, and his attorney didn't show up. And he was on leaving out of the country, so there was another attorney that stepped in. So he asked that attorney to read this and kind of help me understand what I'm signing for on this plea bargain. Okay, and sorry about the noise, but the question on there was, are you a U.S. citizen? And he hesitated about that. I guess he's heard through the grapevines about U.S. citizens, right? And been 14th Amendment type of deal. So he hesitated. And then the attorney asked him, well, are you a sovereign citizen? Well, he hesitated on that too. But he was more puzzled about that question than anything else. And of course, luck had it, I was listening in the conversation. And it piqued my little ears. I thought, this is interesting. And he said, well, the reason why we're asking this is because if you are a sovereign citizen, that you will be sent to federal. And not only that, you'd be held in, now I can't even think of the name, immigration deal. And if you say you're not a U.S. citizen, well, you're going to be held in immigration as well. So this right here is kind of interesting, the sovereign thing. And since he spoke that, and I was just like, wow, that's shocking. And if you see a few videos back on me now, right, 1940, Truman, okay, said that U.S. citizens is American. Well, since we are operating in the United States, and the United States is separate from the United States of America, well, that's two different jurisdictions, right? You got natural rights or people rights in the United States of America, not the U.S. United States section. So I thought that was interesting myself. Okay, again, I'm arm's length. Do your own education, your own research, and all that, right? But let's see what he has to kind of say about this. Now, I've seen this video, so I don't 100% agree exactly what he's saying because there's a 1837 Supreme Court case saying sovereign citizen is the people prior to the 14th Amendment. Now, that being said, if you want to get really good information prior to the 14th Amendment, they're talking about the sovereign people. Okay? But there was one case saying sovereign citizen is the people. That being said, has to be sovereign citizen with the capital C, not the small c. Okay? That has to be done. There's no ifs, ands, buts. It has to. All right? But how can we use it against them? By calling us that. Just because we want to know the nature and the cause and we want our common law rights restored and our natural rights restored. And we want to be in that courtroom as men and women, not subjects. Right? So, there you go. Let's go. By the way, this is High Frequency Radio, and I've done a couple of his videos already. All right. But the best results is go to him.
In courtrooms across the United States.
Sorry about that, I muted.
Justice without labels. Why sovereign citizen is a dangerous slur, not a legal argument. Introduction. A growing legal concern. In courtrooms across the United States, a subtle yet dangerous practice has taken root. Litigants raising valid legal questions, often regarding commercial remedies, constitutional rights, or due process, are being silenced with a single label, sovereign citizen. This phrase is more than a buzzword. It's been used to stigmatize, defame, and dismiss parties before their arguments are even heard. At SBC University, we believe in empowering people with the knowledge of their rights and the tools to assert them lawfully. That includes knowing how to recognize and defend against courtroom tactics that violate due process.
And I think that's his web channel there that you can go to get a little bit more educated.
Organization of language in law. Sovereign citizen has become a weaponized label, deployed not as a legal classification, but as a prejudicial slur used to imply extremism, fraud, or criminality. Courts and government agencies have no legal basis for using this term as a substitute for argument or evidence. Let's be clear. There is no statute, rule, or court doctrine that defines or validates the term sovereign citizen. Yet, once this label is used in a courtroom, it has devastating consequences. It poisons the record, it creates judicial bias, it deprives the litigant of a fair and impartial hearing. What federal courts have actually said. Federal case law is unequivocal. Courts must evaluate legal claims based on merit, not stereotypes. Use of the term sovereign citizen to discredit a litigant's argument does not relieve the court of the duty to evaluate the claims on their merits. U.S. v. Phillips. Judicial integrity requires neutral evaluation of pleadings without prejudice based on identity or perceived affiliations. Caperton v. Massey. Even the appearance of bias violates due process. Offit v. U.S. The courts have spoken. Labels are not law. Legal and ethical violations. Injecting the term sovereign citizen into a pleading without sworn admission or factual foundation is not neutral. It's abuse of process, violating multiple legal standards. Rule 11b1 of the Federal Rules of Civil Procedure, improper purpose. Rule 11.
And I'm going to go a step further. That's usurpation, is what the founding fathers call that. Usurpation. And if they're using usurpation against you, they just committed trespass, battery, and domestic abuse against you. Boom, 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 boom.
B3, lack of evidentiary support. 28 U.S.C. 1927, multiplying proceedings unreasonably and vexatiously. Worse, this label can qualify as defamation per se under civil law, especially when used by government actors under color of law. Real world impact, prejudice in practice. Using this term implies criminal behavior, domestic extremism, anti government ideology. Yet none of these assumptions are supported in court unless facts and evidence are presented. Still, thousands of pro se litigants have their cases derailed by nothing more than name calling. This is not justice, this is judicial profiling. SBC University's position. At SBC University, we do not promote unlawful behavior or political extremism. We teach our students how to navigate the Uniform Commercial Code, how to assert contractual and constitutional rights legally, how to engage with the court system respectfully and effectively. And we demand that courts treat every individual with dignity, neutrality, and fairness, regardless of what claims they bring or what terminology they use. Action steps for litigants. If you're ever labeled a sovereign citizen in court, here's what you can do. Number 1, file a motion to strike the term from the record. Number 2, demand evidentiary proof if the label is used by opposing counsel. Number 3, cite federal case law affirming your right to be heard on the merits. Number 4, call out bias where it appears, even if subtle. And number 5, document and object to every use of inflammatory language. Want help drafting these motions? SBC University's legal literacy courses can guide you step by step. Final thoughts, law over labels. The courtroom must remain a place of truth, not tactics, a place for justice, not judgment, and above all, a place where your rights are respected, not erased by a label. Let's call it what it is. Sovereign citizen is not a legal term. It's a slur. And in a just system, slurs have no standing. Stay informed, stay empowered. Subscribe to our SBC Insider newsletter. Enroll in our course, Due Process and Defamation in the Courtroom, or book a consultation with an SBC advisor today. SBC University, powering private knowledge, preserving public freedom.
There you go. So, do as you wish. Go check out his YouTube. He's got really good content over there, by the way. Now, obviously, I'm just one man, and I don't spend all my time on YouTube. So, I can't go through every one of his catalogs. The ones I've been through, very, very informative. And then, of course, I watched a couple others. The 10th Amendment, for one. You get the original intent. So you need to check out the original intent with the 10th Amendment. Obviously, again, I can't go through all that all by my little lonesome. So, there's just a couple of them right there. Okay? And how much power would you have once you got the basic of the original intent? You have this backing, and understand the common law of using nature and the cause.